Good morning, colleagues. Good morning, colleagues. May you also, we want to test from Judge Moore if she's also able to share the screen.
Of
Judge Moore?
what, Mr. Paul?
Yes.
Good morning.
Morning, colleagues. I see
Morning,
she's already a co-host.
Yes.
Yes. Judge Moore, can you share the D version on the screen?
Okay, good, Ndati.
Good morning. I'm trying to share.
Okay.
Are you able to see the document?
When you do it, please remove.
Yes, we are able to see the document.
Yeah, on your left-hand side, there's that all tools.
Okay.
Just remove it.
Perfect.
Yes, you must do it like that so that
Okay.
it's easy to follow properly. Thank you very much. Yeah, thanks.
Thank
You
you.
can unshare.
Okay.
Thanks.
Mr. Masemula. Paul.
Oh, I was muted. Mr. Manele?
Yeah, maybe introduction just to underscore that in terms of your analysis of panel mandates, the department is happy that all professors are voting of the bill.
Yeah, I get it. That will come after they've brought their mandate, isn't
Yes.
it? Yes. But for now, we just give them clause by clause, and when we finalize that, then we
Right.
can then say that part.
Okay, Ntate.
Sharp.
If I may ask Paul. Hello.
Yes.
Okay. I wanted him to, I don't know if he's aware of maybe the preferred approach, whether they would want us to read clause by clause or to indicate what each clause entails.
We discussed that with Mr. Masemola, whatever option that we think it will be practical for you. But my advice will be if you go clause by clause, it will, in the interest of time, will cover all, including the amendments in the bill.
Okay, thanks.
Is it understandable?
Yes, thanks.
Good morning, Fuad. Fuad?
Good morning, Chairperson. Good
Moss?
morning, can you?
Chairperson,
All of you.
Chairperson.
Yeah, answer my call. I'm going to call you now privately.
Okay, Chair.
Recording in progress.
Good morning, honorable members. We are going to start with our meeting.
Good
Wasting
morning,
no
Chair.
time.
Think they-
We will be starting in a minute. I just looked at the roll call in terms of who is present. I'll just quickly do that. It's myself, Honorable Bayers Smith, Honorable Martha Bartlett, Honorable Kenny Mutsamai, Honorable Audrey Maleka, Honorable Rikas Badenhorst, Honorable Shahid Sheikh, and Honorable Zoleka Ndongeni. Yeah, it's 11 o'clock. Let's start with the meeting. Let's not waste time because all members are aware of this important meeting and they are supposed to be part of this meeting. They are supposed to have logged in. This is an important meeting of our committee. And I want to take this opportunity.
Yeah, you didn't mention my name. I'm on the meeting.
I have Honorable Kenny Mutsamai from Gauteng. I mentioned your name, Honorable Mutsamai. Don't worry, I did. You didn't hear that. I was saying that this is an important meeting, a meeting that is going to consider the Housing Consumer Protection Bill with all the related processes which unfolded since we started with this particular bill. As I said, you are welcome to this important meeting. Yeah, welcome. In terms of the apologies, Moss, can you note any apology?
Chair, we haven't
Present any
received
apology?
any formal apology from the members.
No formal apology from the member. or any
Yes,
member.
Chairperson.
Okay. All right, thank you very much. No apologies, but I think we're forming a quorum, and as such, we are going to proceed with our meeting. More than that, anyone who has joined us? Yes, I think let us proceed with the meeting. As I said, I welcome everybody to this meeting, all members of parliament, provinces, departmental officials from COCTA, any other department, officials from parliament. You are all welcome to this important meeting. As I said, the agenda is before us. We are going to table the bill clause by clause. After that, we are going to look at the final mandates from provinces. After that, we will then consider with a view of adopting the committee report on this important bill, and then we'll close the meeting. It should not be a very, very long meeting. It's a very, very straightforward meeting, especially when all provinces are supporting the bill. All 9 provinces. Thank you very much in that sense. Can I invite an official from? Oh, okay. I see the hand of Honorable Bayer Smith. Over to you, sir.
Thank you, Honorable Chairperson. I'm audible.
Yes, you are.
Thank you, Chair. Chairperson, I want to hear, in terms of presenting the bill clause by clause, what is the purpose of us actually going clause by clause if the mandate says that we either support or reject the bill? The second thing I want to know is that if if we decide, that there's something wrong with the clause, will it be sent back to the provinces at this stage? Because that is quite confusing to me.
Yeah, we'll discuss it. But in terms of the procedure, we are bound to, because we have allowed provinces to look at the bill. They make their own input. We did what is called both the C list and the D list. We incorporated everything. And in terms of the procedure of Parliament, we are going to present it formally. And I'm advised that this is how it should be done so that it becomes clear and it is recorded in terms of how we process the bill. I hear your point, and well, I don't know. We'll deal with it when we cross that bridge, when there are issues, but I doubt that there would be issues. But I think just your question has provoked my mind. It's provoked my mind to say, what do you do under the circumstances? Let's do it when you cross that bridge. Let's do it when you cross that bridge. I suggest so, Honorable Smith. With that, can I invite? I'm told that a certain Mr. or Miss Jashmo Chikomba will be the one, together with the team, that will present the bill clause by clause. Over to you. And flight it, please. Can you just flight it?
Good morning, Chair, and the members. My name is Mato Pitsusi. I'm the Acting DDG Corporate Services in the department. I am with the team that has been working on this process, led by Mr. Paul Masemola, who will be making a presentation to the committee. From the department, it will be Mr. Masemola, Paul Masemola, Ms. Judge Mochi Komba. And from the NHBRC, it will be Ms. Bongile Ngwenya, Mr. Ezekiel Mthongo, and Ms. Nkadisha Raseboza, and Ms. Natasha Foshe. So those are the colleagues who've been working with the committee through this process, Chair, and they will be taking the committee through the presentation. Thank you, Chairperson.
Okay, it's fine. You can proceed. I'm waiting. We're waiting.
Good morning. Good morning. Honorable Chairperson, honorable members, my name is Judge Mochi Komba, and I will be taking you through clause by clause reading of the bill. Thank you. I'm going to start on the objectives of the bill, and which reads as follows. To provide for the protection of the housing consumers, to provide for the continuance of the National Home Builders Registration Council as the National Home Building Regulatory Council, to provide for the registration of home builders, to provide for the enrollment of homes in order to be covered by the home warranty fund, to provide for the regulation of the conduct of home builders, to provide for the continuance of the home warranty fund, to provide for the claims against the fund, to provide for the funds of the council and for the management of those funds, to provide for the procurement and contractual matters in relation to the building of a home, to provide for the enforcement of this act, to repeal the Housing Consumers Protection Measures Act of 1998, and to provide for the matters connected therewith. I will then take you through the different chapters of the bill and concentrating on the clauses and what the clauses entail. Chapter 1, interpretation. It deals with the definitions in the bill, and section 1 reads as follows. In this act, unless the context indicates otherwise.
Wait. Are you going to read everything? No. Take us clause by clause where there were amendments. Or that's my understanding. Moss or any person from the legal section, can you help us? I think the question that Honorable Smith asked comes in. You can't read everything that we see here. It can be. Just wait a bit. Moss, I need that advice. What do we do under the circumstances?
Chairperson, I think you are correct. In an interest of time, there were C lists that contained proposed amendments. And those amendments were incorporated into a bill to form the D version. I think for record, the department can just confirm that in this bill and take members through those sections where those amendments were effected. Thank you.
Yes, I don't want us to do something that will be challenged in future, that will be unlawful, that will be unprocedural. That's the point that I'm making. But you can't read the whole bill. We know this bill, we have read it, and the question that Honorable Smith raised, luckily, is a very valid question. You can't do that. You must just pinpoint all those areas of concern which were incorporated based on the final mandate from the provinces. We sent this to the provinces. They gave us their negotiating mandate. We developed the C list. We took it to the provinces, and the provinces have given us their final mandate. We have this. We have dealt with this for almost a year now, and we can't read everything that is here. We can see it. All that I'm saying is that we need to find a way that this can be processed without any hassles and without deviating and without breaking the rules of Parliament, because we can be challenged legally if we do so. All that I'm saying is that we must do it properly, but we can't be reading clause by clause. Madam, I suggest that take us to the areas where there were, just say clause number, chapter 1 or section 1 deals with definitions. You can see it. There is anything that is a problem, maybe we go to the next one, but you can't be reading it. And when I said clause by clause, to read it. Yes, can we do that? Just say chapter 1, there are definitions. If there is anything that is of material significance, then alert us. If there is no, go to section 2, go to section 3 until you finish. And actually, I wanted those that were material where there were serious amendments, so that we must look at those provisions. And I'm not rushing the meeting. I'm not rushing anybody. I know that everybody is busy, and that the focus has changed a bit because of the elections and all of that. But that doesn't mean that we mustn't do our job. But at the same time, it doesn't mean that you must subject us to this situation. Yes, chapter 1 deals with section 1 or chapter 1. Section 1 deals with definitions. Anything that is of material significance that we want to bring to our attention, we go to the next one until the last one.
Thank you, Chairperson. I'm going to do that. Just give me a second so that I can open the documents that shows the amendments that were effected on the bill.
Yes, that's what we want.
Thank you. Thank you.
And I wonder why we're not ready for this. What are you expecting? To stay here for 5 hours or 6 hours, department? That's you reading us the bill that we have, that you've long sent to us. Not fair to us.
Yeah.
Not fair to members of Parliament. You would have been ready for this, and you know which areas that are of significance, where there were amendments, and how you have incorporated of your department, as well as the negotiating mandates. You should have known that.
Chairperson?
Yes?
Yes, it's Paul Masemola. May I just take
Yes,
over and
yes, Mr. Paul Masemola.
Just direct it. Thank you very much, Chairperson and honorable members. Chapter 1 of, I'll just go through it and I'll indicate where there were areas of concern, and so that we are able to deal with it.
Yes.
Chapter 1 of the of the bill deals indeed with interpretation, and chapter 2, I do not, in chapter 1, I've not picked any challenges there. And on chapter 2, it deals with National Home Builders Regulation, the objectives of this bill, and the continuation of the National Home Building Regulatory Council. That's what it deals with, including the board, the qualifications, composition of the board, and qualifications of the board members. It deals with those governance issues, including the appointment of the chief executive officer and chief executive officer and chief financial officers are appointed there with their qualifications and disqualifications, including the staff, the constitution, or rather the staff of the council, and the disestablishment, how it can be disestablished, this National Housing Building Regulatory Council. Chapter 3, or rather in page 7, which is, or rather part of the definitions, I may just indicate that it does have on line 53, we had included technical standards. It was technical changes that required that for consistency, it must be on caps, so that it's not on small letters. On chapter 2, chapter 3, sorry, honorable members, is on the registration and home builders and developers. This is where we had also, on the amendments on C list, we had included and developers, because initially it was not including the developers. So we have included it on the heading. It deals with the register of home builders and the developers. Maybe I can be made to share the screen so that it's easy for me to refer easily to that. In the meantime, it also deals with what should be contained in the register, the home builder and the developer as the people who need to be registered. I'm sorry. What are the requirements for the registrations, cancellation, suspension, and amendment of home builders or developers registration, and the grading status of them. It also finally includes the liability of unregistered home builders and developers. On chapter 4, sorry, just pardon me so that I go to the actual chapter. On chapter 4, it deals with enrollment, which indicates that the homes must be enrolled, and what are the cases where there will be a failure to enroll a home, and duties in respect of housing, subsidy housing projects, where the municipal manager, HODs are responsible to assist in ensuring that the home are actually registered, enrolled on where there is a subsidy, and also the responsibility of the MEC and MMC on ensuring that they are performing their oversight responsibility in ensuring that they comply with the Act. Chapter 5 deals with financial matters. Of also importance is also that it also deals with the appropriation of money from Parliament. In the current form where we are now, the current Act, it doesn't have that part. It has been included in this bill that the money will be appropriated from the Parliament. It also deals with the home warranty fund and the additional money that the board can source and how it should be managed, including the bank accounts that it must be saved in to follow the Public Finance Management Act when doing that, including the management of those funds. The fees also are included in that, how the fees can be dealt with. Maybe of importance also, let me just refer to clause 39 subclause 5, which indicates that the council may escalate the fees prescribed in terms of subsection 1 in accordance with this section. But if the council escalates those fees in excess of the most recent publication by the Statistics South Africa of the Consumer Price Index, the council must obtain the approval of the minister prior to the publication of the notice contemplated in the subsection. So there are checks and balances to ensure that there is no arbitrary increase of fees that will be charged to the homeowners, home builders and developers in that regard. Part 2 of it deals with claims and recourse against the home warranty fund. So it indicates when the warranty will commence and when, including, or rather, let me give that for home warranty for structural defects, it is now starting at the time when the house is being built, and it will also take 5 years after the home has been occupied. On the home, the roof leak, it also starts when the home is being built, but it's only limited to 2 years after occupation of the home. So it has been extended to 2 years period initially, or rather, as the current Act, it's 1 year. Now in this section, it is extended to 2 years. And also before occupation of the property, or rather the home. The other section deals with, which is section 41, deals with claims and limitations. It deals with instances where the homeowner cannot claim from a warranty fund. where there is willful act or willful omission of the housing consumer or persons residing in the home, which leads to the damage to the property, which has nothing to do with the home builder or developer, the reasons for the damage. So they are excluded. It deals with the claims and recourse, how the claims can be processed. It finally deals with the minimum and maximum amount payable by the warranty fund. And it indicates that the minister may, by notice in the Gazette, determine the minimum and maximum amounts which may be expanded under Section 42 in respect of any home due to a major structural defect or roof leakage, which cost may or may not be included in a claim contemplated in Section 42. So minister will still make a determination of how much and all that. Chapter 6, it's a compulsory information and contractual matters. This section tries to ensure that home builders are actually protected against situations where they work, but they are unable to get money because they are being told that we are still waiting for the money, but they would have, on their side, they would have provided the service because they would have worked, build a home, but it's prohibited in this act that their payment should not be dependent on some other circumstances which has nothing to do with them. So when they work, they are expected to get the payment for the work that they would have performed. It deals with contractual matters which at least alleviate some challenges to, especially even the small contractors, to ensure that there are things that should not be included in the contract, or those that at least should be included in the contract, to ensure that even the homeowner gets comfort that the home that is being built, it is a proper home. For example, I would indicate that the homeowner, depending on whether it has been constructed or is to be constructed, is or must be construed in constructed in a workmanlike manner. It must be fit for habitation. So a constructor, when he's constructing a home, is actually saying this is the home that is habitable in terms of the clauses that should be included there, and also includes the cession of rights. And it says that any successor entitled to the housing consumer has all rights under this part exercisable by or available to a housing consumer within the period contemplated in Section 41. As I've indicated earlier, that it also gets some the prohibitions that are included in the act, in the bill, to ensure that the home builder are actually, the homeowners are actually protected in this instance, including the entitlement of progress payment for the constructors, home builders. And part 3 of it deals with adjudication of contractual disputes. As we all know that court processes do take some time, and it's difficult sometimes, even financially, for some, largely the small contractors, to find them, even the homeowners, to find themselves in in court trying to enforce the contractual obligations of the home builder. So this clause does assist in that to ensure that there is adjudication of those contractual disputes that will be speedy and ensure that there is clarity on how to resolve them. Even the limitations of dates, I mean the number of days that this matters should be resolved. Chapter 7 deals with the enforcement and alternative dispute resolution, which deals with the fact that the non-enforcement will definitely attract penalties, and that the compliance and enforcement committee will be constituted, which will have powers and not, powers that will ensure that there is indeed compliance in terms of the Act. And therefore, it is also having powers to meet fines against the transgressors. There was a request to make amendment on clause 64, where 64, I think we needed to on where we also included technical standards to be on caps so that it's consistent, but we also included online that we needed to include section 64 65, the last paragraphs, sub paragraph 7, which initially it was saying 64, and it was an error which was then corrected to mean 65, section 65. On chapter 8, or rather it also, chapter 7 also deals with the penalties that are there. And I'll read section 78, that says any person, including any director, trustees, managing member or officer of a home builder or developer who is convicted of an offense in terms of section 72, 73, 74, 75, 76, or 77 is liable to a fine not exceeding 1.5 million or to imprisonment for a period not exceeding 10 years. And this is more of a deterrent also to would-be offenders in this, not to take these offenses very light, to ensure that there is indeed a teeth to bite in these instances. On chapter 8, it deals with miscellaneous aspects, which include vicarious liability and law of agency, the liability of a home builder. And I'll just read this one, which says that in the case where a home builder or developer is a partnership, trust, company, or close cooperation, a principal of that home builder or developer may be held personally liable in terms of this act and may be prevented from registering as a home builder or enrolling a home in terms of section 25 or 30, as the case may be, by the council before he or she has complied with any instruction in terms of this act, and on the conditions and in the manner prescribed by the minister. So this ensures that nobody will undermine the compliance notices that would be issued, and to say you must first rectify the home before you proceed, so that they will know that they will still be liable. It deals with the duty of the property practitioner, duty of the financial institution to ensure that they do before allocating, or rather on the home loan, make sure that before they issue a home loan or grant it, they also ensure that the act is complied with, including the conveyancer's duties, to ensure that when they are transferring properties, they do make sure that the requirements of this act are indeed complied with. The recoveries of fees, including the home building manual, is also complied with. It also deals with the regulations, which is clause 86, which indicates that minister will be responsible for issuing regulations. And I'm sure in quite a number of sections, it is clear that minister would still have to issue those regulations to ensure that when the act comes to effect, there are those regulations that ensures that it's easy to comply with the act. And those regulations will be gazetted so that there is clarity as to what and published, so that the public can be able to interact with them, and the rules that the board may recommend to council to ensure that the act is properly operational and implementable. Section 88 deals with the liability of members, staff, accredited representatives, experts, and advisors of the council. So this section just ensures that, or rather, let me just read it, so that a member of a council, member of a staff, an accredited representative, expert, or advisor of the council is not personally liable by virtue of any report, finding made or expressed in good faith in terms of this act. It also deals with the code of conduct, and it says that the minister must, by notice in the Gazette, publish a code of conduct for members of the board. The council must, by notice in the Gazette, publish a code of conduct for home builders and developers, and may publish a code of conduct for other role players within the home building industry. So the first code of conduct is the one that will be made by the minister for the members of the board. Since they are not employees of government, they must abide by the conduct, the code of conduct of the board. It also deals with the repeal of these laws, which indicates that the Housing Consumer Protection Measures Act will be repealed by this bill. Once it becomes to act, it will then repeal this, the current one that we have, which is Housing Consumer Protection Measures Act. And it deals with the savings and transitional provisions that ensures that there's a seamless way of ensuring that there are no gaps that are left when we move to the new act from the current one that is being used. so that there are no gaps that are left and situations where there will be no clarity as to what should happen. And lastly, it deals with the short title and the commencement of this act, which indicates that this act will then be commenced on a date determined by minister by notice in the government gazette, and the different date may be determined in relation to different sections of this act. Notwithstanding subsection 2, the minister may relax any provision of this act for a period not exceeding 2 years with a view to the equitable implementation of this act. So it will ensure that even if there is a delay of implementing this act due to one reason or another, it is important to note that it will not be a delay of more than 2 years. Within 2 years, this act should be operational if there are delays for one reason or another, as I've mentioned. Lastly, it deals with the object of this bill, which would have indicated which part of it is in the introductory part of this act. Thank you very much, Chairperson.
Thank you very much, Mr. Amasemola, much better.
Thank you.
That is that, honorable members. The bill has been presented before us, chapter by chapter, clause by clause, section by section, and in the course of doing that, the presenter highlighted most of the crucial aspects pertaining to this clause. I want to open this for any comment, any question, any issue that honorable members would want to raise. This is very, very straightforward. Anyone? None? 3, 2, 1, 0. No comments. It means that we have noted and accepted the presentation in terms of the submission, clause by clause, of this particular piece of legislation. Now let's move to the next item. The next item would be the final mandates from different provinces. As I indicated from the beginning, all the provinces are supporting this piece of legislation, which is very, very much important. But formally, I want to table the final mandates per province. Starting with the Eastern Cape, can someone from the Eastern Cape just indicate that? If they are not, I will help them to do that.
Eastern Cape supports, Chair.
Eastern Cape supports, yes. Thank you very much. Free State? No one from the Free State. Honorable Mikalakis is not here, but as we indicated, we received the final mandate from the Free State. The Free State province supports. Gauteng? Honorable Samai, you are in the meeting. You reminded me that you are in the meeting. Say something. Honorable Samai is not there, but we know that the Gauteng has also tabled his final mandate in terms of supporting the mandate. The next one is KZN. Anyone from KZN? Honorable Mthethwa is not part of this meeting. I'm moving. KZN also supports the bill. Limpopo?
Chairperson, thank you. Limpopo supports the bill.
Limpopo supports the bill. Thank you very much. Mpumalanga?
Chairperson, Mpumalanga vote in favor of the bill.
Mpumalanga support. Northern Cape?
Northern Cape supports, Honorable Chairperson.
Thank you very much, Honorable Bartlett. And Northwest, I support. I stand here before you on behalf of the province to say I concur, I support. And lastly, the Western Cape.
Thanks, Honorable Chair. The Western Cape will support the bill.
Oh, wonderful. All the provinces, 9 provinces, are supporting this bill. Thank you very much, honorable members. The next step will be to consider the report and adopt the report of the committee. Moss, can you just fly the report? As we are all aware, this report is of the Select Committee on Cooperative, Water, Sanitation, and Human Settlement in respect of the Housing Consumer Protection Bill. That is dated the 26th of March 2024, that is today. I would like Moss to take us to recommendations. You find conclusions and recommendations, especially recommendations. Moss, can you read that on our behalf? We are aware that we have followed a laborious process in terms of briefing the provinces, the A-list. The provinces gave us their negotiating mandate. We developed the C-list. We incorporated the C-list with the comment. We produced the D-list. The D-list went to the provinces, and that we obtained the final mandates from the provinces. And that is where we are. That is what we are doing today in terms of the processing of this bill. Moss, can you take us to the last part, which is recommendations?
Thank you very much, Chairperson. And as you have outlined, Chairperson, our 6.2 chair reads as follows. Having considered and deliberated on the objects of the Housing Consumer Protection Bill, B10D 2021, classified as Section 76 by the Joint Taking Mechanism and referred to it on 14 November 2023, the Select Committee on Cooperative reports that it has agreed to the bill with proposed amendments. The report to be considered. Thank you very much, Chairperson. Chairperson?
Thank you very much, honorable members. That is the report. Any comments, any view, any suggestion from members?
Chairperson?
Yes, Honorable Sheikh.
Thank you very much, Chairperson. Chairperson, I am in agreement with the report. I would just want to propose that it's 6.2, where we make reference to the Select Committee on Cooperative Governance and Traditional Affairs, that obviously the initial letter should be caps. And that being said, Chair, I think that we should be ready then to move for the adoption of the report.
All right, thank you very much, Honorable Sheikh. Do that, Moss. Select Committee on Cooperative, man. Come on, who kept those letters? Be professional and meticulous, please. Thank you very much for that observation, Honorable Sheikh. Honorable Sheikh has moved that we support and endorse this report. Any seconder?
Honorable Bartlett, second, Chair. Honorable Chairperson.
Bartlett supports the bill and the report that we adopt this report. Any objection to the support of the bill? No objection. It means that the report in respect of the Housing Consumer Protection Bill is adopted, is duly adopted. The bill has been adopted. The report has been adopted, as I indicated, and that the matter will be referred to the House promptly, maybe this week or next week. We are not sure. It will be scheduled so that the House must adopt this particular bill. With that, honorable members, thank you very much for attending this meeting. I know that all of us are very, very busy in terms of the work that we do. And I wish you good luck in your future endeavors. Thank you very much. The meeting is adjourned. I thank all the officials of Parliament, entities, as well as the department in this particular instance, as well as the province, because without them, we wouldn't have succeeded in the way that we did. They put a lot of work within a very short space of time in terms of supporting us, in terms of public hearings, in terms of public participation. That was meaningful. And we are thankful. We are always grateful about that kind of support. The meeting is adjourned. Thank you very much.
Thank you, Chairperson.
Thank you, Chairperson.
Thank you, Chair. Comrade China. Comrade China. Comrade China.